Welcome. We're going to be talking about ethics for FDR practitioners, and as part of that, talk a little bit deeper about the role as well. Before we progress, I'm on Gunai Kurnai country in southeast Australia, and want to acknowledge the traditional owners of Australia and pay respects to elders past, present and emerging. I'm the director of Mediation Institute, a family dispute resolution practitioner and nationally accredited mediator. At Mediation Institute, we train FDR and national accreditation, and we are a complaint handling body. So a lot of what I've got to say also relates into the sorts of things that happen in terms of complaints. But general overview of what I wanted to talk about is, what are ethics? Why do they matter? The professional standards and obligations that relate to us in this role. We'll talk about some of the clear and some of the grey areas and where you can get guidance. So if you think you're in a grey area, always get guidance. And there's a couple of tools and information as well that I'll share. So ultimately, ethics in the general meaning of the word are moral principles that govern a person's behaviour or conduct of an activity, and it tends to be cultural and specific to a particular area. And if we're going to use these meaning-laden words, morals are principles or right and wrong behaviour and what's considered acceptable in a particular context. So just in the definition of what a moral or an ethical principle is, you can see it's full of ambiguity and depending on context. But ethics, how we're perceived, play a really big part in our level of trust. So if you're seen as an ethical practitioner, you're going to have a reputation of trust. But in our industry, in the dispute resolution industry, ethics, or what has been considered acceptable, has been converted into standards and regulations. And of course, ethical standards and obligations apply for those of you that are lawyers as well, that if you breach those, you get in all sorts of trouble. Now, compliance with ethical standards is mandatory because your registration order depends on it. So if there's a complaint and you're found to be in breach, then you could have your national accreditation or your FDR registration cancelled or suspended until you show that you are aware of your obligations and complying with them. So just as a bit of an overview, there's a number of different layers that you will have to understand and comply. And in the course, in the FDR course, there's a module on that, and it goes through particularly the FDR regulations, which are our rules, and something that you really should be checking back with regularly. They've been interpreted by the Attorney General's Department into the form of a number of fact sheets, and you would have come across some of those fact sheets and links to those in Module 1. The Attorney General's Department does update those from time to time, so it's good to just keep a little bit of an idea on what's current, but basically they relate back to the regs. The Competition and Consumer Act, Trade Practices Act formally, which is administered by the Australian Competition and Consumer Commission. So that just relates to your commercial obligations as a business owner. So those that are working independently. So any competitive practices and collusion and all of those sorts of things are administered there, not specifically for our industry, for any industry. If you're looking at setting up referral programs or things like that, you may need to have a little bit of a think about some of those sorts of things. They cut a little bit close to the bone at times. Particularly, there's been a little bit of a trend in one-stop shop type processes with lawyers and mediators working very closely, and sometimes that can be seen as actually not really independent. So thinking about that if you're invited into wanting to set up something like that. Mediator accreditation system, that's administered by the Mediator Standards Board. It's currently under review. There was a major review of the system. The National Mediator Accreditation System is the regulations that relate to your work as a nationally accredited mediator for anything other than family law mediation. If you're both an FDR practitioner and an NMA standard and mediator and there's a conflict, the FDR regs have precedence. There's not a lot of conflict between them. And if you're a member of Mediation Institute for your complaint handling, we've got ethical standards which have been developed based on those requirements. Once again, another way of looking at how they work. If you're a lawyer, your legal practitioner obligations will be state-based. Psychologist, other obligations. With coaching, it's all a bit fragmented. If you're part of the ICF, International Coaching Federation, or anything like that, they've got, again, industry obligations, but there's no sort of legislation other than normal consumer business obligations. So that's the landscape. Any questions or comments about that? No, you're all good. So for mediators and FDRPs, the 4 big areas to be really thinking about. Now, good conduct. As a mediator, you have to be a person of good repute. If you've been convicted of a crime related to violence, for example, that's something as an accreditation body I would have to take into serious consideration whether you're a fit and proper person. So this is not related to being violent to a client, related to your actions or also comments. I had one case where a nationally accredited mediator was having a family breakup and he pretty much lost it, and he was making threats on Facebook towards his ex-wife, bomb-making posts and like really bad things. And we had to say, look, you're not in the right state of mind to be a mediator, and we're going to have to suspend your accreditation because that's not okay. Crimes of dishonesty as well. So if you're convicted for fraud or things like that. So it is a role where your ethics, not just with clients, but your visible ethics in your life actually can be evaluated in terms of your suitability. Any comments or thoughts about that? Confidentiality. So clearly confidentiality is a really important foundational element of mediation. So it's generally confidential. We need to keep confidential information confidential, and we must never, of course, use information obtained for personal gain or advantage. The clients, particularly in family law, are very vulnerable at times, and it is possible to take advantage of them. That's something that can occur and come out in a complaint that a mediator has not acted properly. I've got the little cross arrows because the confidentiality in our duty of care, there's definitely a balancing act there because we are mandatory reporters. So if we make a mandatory report, we're breaching confidentiality. We have no obligation to tell the parents that we're going to make a mandatory report. We can do that without informing them. We may choose to inform one of the parents, not. It's totally up to us and our professional judgment about whether it's going to increase or decrease the risk for the vulnerable children. Remember, mandatory reporting is only related to risk of abuse or neglect for children. We also have an exemption from our obligations that we may breach our confidentiality if we feel that there's a risk of harm to a person or property, or that there has been a crime committed, that we have an obligation. Yeah, so also mandatory reporting for DV. I knew it was mandatory reporting for child abuse. Oh, that's good. So Fiona, yeah, were you going to say something?
Yeah, it's very unique in the NT. All adults have an obligation to report any harm or imminent risk of harm in relation to domestic and family violence.
Yeah, no, that's
Love that.
Yeah,
that's great.
So how does that occur as a lawyer?
Yeah, overrides our obligation of confidentiality.
Good.
Yeah.
I keep saying, every time I get a chance to talk to lawyers, I say, I think lawyers should be mandatory reporters, and they all say, oh, no, that's impossible. And I think, oh, I don't think it is.
Yeah. So the way we do it, not everyone does it this way, but at Legal Aid is we tell the clients in advance, everything you tell us is confidential unless we're required to report it by law. These are the circumstances we might need to report it, child protection or DV, if it hasn't already been reported. And then they'll tell us, and then we'll say, look, what you've just disclosed is something that I will need to report if you haven't already or if you don't want to. And we 9 times out of 10, someone's already reported it, so then we don't have to. But the last 10th out of 10 time, either people say, yeah, no, I really did want to report that, I just need some help to do it, and we can help them do it. Or they might say, look, I don't want to report it, but I completely understand why you need to. And we haven't ever had a situation where a client said, that's bullshit, I don't want you to report it, because usually they're making the disclosure about someone else. They don't usually make a disclosure about themselves, even to their lawyers, because it's usually in the child protection or DV space.
I think my concern is, like, as a mediator, does that just then put you at risk of violence?
Could. And that would be the case where you maybe not have that discussion in that way. And it just depends on the circumstances. And we'll talk about that in the course about safety planning for FDR safety and their safety. So Fiona's in an environment where there's some protections built in.
Yeah, and also in terms of when we report, we don't have to report it immediately if that could pose a risk of harm to yourself or another person. Oh, sorry, I was talking about in the solicitor-client context, but in the FDR context, look, it's just so widely known here. It's just, it's not a shock to anyone when we say it. So it's a bit different. Yeah, when it was first introduced, everyone was like, oh my God, how's that going to work? This guy's going to fall in. But everyone kind of really understands it. So, yeah. It's not as complex as you would think. But on the flip side, I don't necessarily think it actually does any good, because our authorities don't necessarily respond appropriately to those reports. But that's a different story.
Yeah, and that's always the challenge, because sometimes they're so overstretched that they really only deal with imminent threats and don't do the preventative stuff.
Fiona, did you say all adults? All adults?
Every adult. And that's the same with child protection.
And can you do that anonymously?
Yeah. So that confidentiality duty of care is definitely a balancing act. In your opening statements to clients, you always buy the exemptions. In your agreement to mediate, it'll be there in writing. So it's not that people can say, oh, I didn't know. So it's not usual that you would have the clients coming back. They've got more than enough problem to go back on you, but it could happen. Now, with professional obligations, the wording is not to provide legal advice unless you're a lawyer. However, your obligations as a lawyer, you can't provide independent advice to two people who have conflicting interests. So it's really not well defined, but ultimately, if you're a lawyer, it's very hard for a lawyer to provide information without it being legal advice, because you are a lawyer. But my advice is generally to keep it procedural, keep it informational. Don't try and provide legal advice at all in the role of an FDR. Just refer them to independent lawyers. It's a slippery slope and you just don't want to be sliding down. So you can identify that you're a lawyer, but I'm not working as a lawyer at the moment. I'm working as an FDR practitioner, so I can provide you with legal information, but you'll need to speak to a different lawyer for independent legal advice. Does that sort of gel with what's going on with your legal aid people, Fiona, as you're aware?
Oh, absolutely, yeah. Yeah, you've got that obligation as a lawyer anyway. So
it's just not providing legal advice unless you're a lawyer does not give carte blanche to lawyers to have at it, because you just can't ethically advise two people with conflicting interests. And inherently the case in a family law separation. Of interest, it's very clearly defined in the regulations what would be classed as a conflict of interest, and particularly you cannot more from, for example, working individually with one person as their legal advisor, being the lawyer, being the mediator, being the FDR. So if you've been providing individual advice, you can't morph into being the mediator. The same way if you were providing individual coaching or counselling or other individual services to one person, you can't morph into being the mediator. Now, the FDR. So you can, if someone's a relationship counsellor and you are doing couples counselling, or you were doing transformative relationship mediation with the couple, you can move on to FDR because you've been working with them both. If someone says, oh, no, I don't think you're independent, don't do it. Refer them off to someone else. We need people to feel and for you to be independent and not have a conflict of interest. So definitely there can't be any financial benefit. You know, I had a case when I used to have offices and we had some rooms to lease, and a client said, oh, I'm looking for some rooms. I said, okay, I can have a conversation with you about that and refer you off to someone else for mediation, or we cannot have this conversation. He said, oh, okay. I couldn't be having conversations about him as a potential tenant and then do the mediation.
At the moment, when I sometimes coaching clients before we go into mediation, I always do that with the permission of the other person, which generally they're grateful for because they feel like one person needs to catch up. But when I do that, I always offer the other person a similar session so that they've got equal time, and I don't email directly. Like any emails that come from me go to both parties.
Okay.
So that I try to stay on top of it that way. And I've only had one situation where I was having more to do with one person, and I ended up having to say that I wouldn't be able to do the mediation because I had spent too much time. I knew too much about this person. I'd become in some way invested. So I passed the mediation off to someone else.
Yeah. And look, that's the really critical thing is disclosure. So making sure everyone's fully aware and that they agree to proceed. You need to be careful with that and really thinking about it.
It can't be ongoing. So what I learned in that situation is that it can be like one session, maybe two sessions at a stretch, but it can't be ongoing because I couldn't avoid.
You can't. You really can't.
Some kind of relationship.
Yeah. So you have to be very careful with that, and not an ongoing relationship. In that case, you're really going to need to stay as the mediation advocate and have someone else.
Yeah.
And that can be very valid and helpful as well. So, yeah, with conflict of interest now, if you feel there's a conflict of interest, don't do it. If you don't feel there's a conflict of interest, but there's some sort of prior relationship, it is possible to continue with mediation, but it has to be with the informed consent of all parties. And my recommendation is always get it in writing. It's worth what it's written on if it's verbal, which is nothing because people's recollections change. So you should have a conflict of interest form or potential conflict of interest. So if it's a conflict of interest, you're not proceeding, you don't need a form because you're not going to do it. If there's a potential, so it may be that your kids may go to the same school as your kids if you're in a small community, or you may have gone to school with the person, or there's some sort of a relationship or whatever, but you don't feel it will have a conflict of interest. The parties feel that it is okay to proceed. And once again, have a look at the regs, have a look at the Attorney General's fact sheets. They are very clearly defined, and it's also in the course. Use your conflict of interest form if you think it is okay to proceed, the parties think it's okay to proceed, but there's something there. Okay. And if I'm missing anything in the chat, please let me know. So on the website, we've got a check sheet, which you might like to use to have a look at some of the potential issues. If you just go to the Mediation Institute website and search for Code of Ethics, that will bring up the page that's got this document. So we've really just taken the Code of Ethics and turned it into a series of questions. This is particularly the case for people that are running their own practice, creating marketing material and all of that. There's some things like we can't guarantee results or imply that we can guarantee results, because that creates a bias in the process where we've got a vested interest in keeping our results up and basically may pressure people into an agreement that they really shouldn't enter. So we don't control that. We control the process. We don't control the outcome. And so if we're implying that all of our cases result in a settlement, that would be unethical and contrary to the regs, and you might find yourself in trouble if someone makes a complaint. So have a look at that, particularly if you're setting up a practice. You'll find on the website as well our complaint handling process, and there's issue codes. So the really common ones that we get are communication discrimination, sometimes cost, often grievance. So a grievance is basically you didn't deal with the complaint properly. You tried to dodge it. You tried to ignore them. Maybe they'll go away. So it's a complaint about a complaint, not dealing with it properly. You have a professional obligation that you must provide information about the complaint handling process available. You don't have to go through a big verbal thing with people, but you need to have it in your agreement to mediate. You need to, if you're working independently, you must have an independent handling service, such as your membership with an organisation like Mediation Institute. If you're working within a service, then there would be a complaint handling process. If you're working within a government-funded service, the Department of Human Services, or whatever their current name is, has a complaint process for FDRPs within that service. So it is a mandatory obligation that you provide people with an escalation, but always try and deal with it first yourself. Most common things people complain about is the Section 60I, because they didn't like what you chose. That's not something that as a complaint handling body we will investigate, because you have complete discretion. No one else has the ability to second guess you. If you're in a service, I know sometimes they do decide those things in a group think. It's not really proper. It really is the FDRP who should be making that decision. And they certainly shouldn't be advocating, oh, we don't use this particular category. They're there for a reason. It's your professional judgment about what it should be. And we'll have another session another time about Section 60I certificates and the various scenarios. So don't worry, we'll get to that. Professional conduct is often the case. I've got a couple of complaints that are active at the moment. I can't talk about them, but sometime in the future we will. But definitely making sure you're being very clear and honest about your credentials, what you're qualified for, and all of those things is critical, because that comes back down to good character. Any thoughts or questions about that? Unqualified legal practice is a really serious issue. For FDRPs, it's generally around drafting court documents on behalf of clients, and that's something to be really careful of. I have had this investigated by the government solicitor because of a complaint. As a FDRP, it's really important to provide well-documented agreements with all of the information required, but I encourage you not to try and draft it in the format of consent orders, and certainly not to draft it onto the consent order application. If you're not a lawyer, definitely don't, because you will find yourself in all sorts of trouble if you are picked up. And if you are a lawyer, there's still, even though it's a consent order, it's still an application, an applicant and a respondent. So once again, you're really putting yourself in a situation you don't need to be. have someone else you refer those sorts of things to finalise, and they can refer their clients back to you. It makes a lot more sense. So providing legal advice was regarded as specifically advising about the client's individual circumstances, rather than saying duty of disclosure means you must provide information about all of your assets and liabilities. And when the client says, oh, we just want to discuss the house and the super, we don't want to talk about the rest. No. Duty of disclosure means you've got to disclose all of it. That's not legal advice, that's legal information. You're telling them this is the obligations rather than more specific advice. So that's just the clause out of the regs. It's really poorly written. I'd like a nice little review of the regs and update, but they don't listen to me. I have told them. Yeah, so drafting court documents. So it just goes in a little bit more detail, the conflict of interest. So previously acted in a professional capacity, previous commercial details, or personally acquainted, but I've already gone ahead of that. I will put this presentation into the course if it's not there already, so that you can follow all of these links. So the consumer law information and so on. If you're not a member of the Mediator Network, make sure you are, so that you can find out when events are on and things like that. And there's a really active and strong Facebook group for FDRPs that I co-host with Fiona Kirkman. If you're not already a member of that, it's really worth being part of that. There's lots of scenario questions, but there's also some really interesting resources and other things that are shared. So I'd encourage you, Family Mediators /FDRPs is the name of the group. Just search that on Facebook. And with the Mediator Network, just apply. And if you haven't already joined, we'll let you in. So I will stop the share. And I've gone a little bit over because we spend a nice amount of time having a bit of a chat in the beginning. Are there any other questions or comments that we should? Yeah, so Family Mediators /FDRPs is the name of the Facebook group. If you just search that, you should get that coming. Excellent, thank you.